Good afternoon. I'm Larry Cates, and I'm going to be presenting the probate records portion of this presentation. Francois Xavier Fauvel, a noted historian of medieval Africa and author of a wonderful recent book of vignettes from that era called The Golden Rhinoceros, has compared the work of historians facing minimal written records to the work of an artist who creates a stained glass window. Because of limited sources and the need to look for alternatives, reconstructing what happened in the past, when and where, why, is more like the art of a glazier than that of a fresco painter. You must first look everywhere possible to find the fragments of the past, and only then try to stitch them together to form a larger whole through interpretation, extrapolation, and context. The historian's work is like the leading that binds the pieces into a whole. And there are certainly different ways that those pieces could be brought together. A different historian might look at those pieces differently. The work of a genealogist, I don't think, is very much different than that. We don't have a complete story. Unless our ancestors were very prominent people who left a lot of evidence, we don't find a complete record of their lives. We may have a family tradition or two to get us started, which we should expect to contain just a kernel of the truth. But we can add to that core, and then we have to look for limited instances when our ancestors brushed up against governmental agencies at whatever level. Finally, we can throw in some private records, if we're lucky, family or plantation papers, for example, newspapers, church records. What we end up with is a box full of fragments that we have to stitch together somehow. That's never an easy task, even for white ancestors or free people of color, but it's particularly challenging for enslaved ancestors because the pieces are harder to come by, and we must look everywhere for them. Often we can't even be sure where to look. The gaps between the pieces are greater and more difficult to fill, and some of what I'm going to show you today will seem trivial possibly to you, but my advice is to pay attention to the details because every little bit of evidence counts in this game. Treat each fragment as precious, store it away, and I guarantee at some point, when placed alongside other pieces from other sources, a larger picture will start to emerge. The focus of my talk today is one particularly fruitful source for the genealogy of the enslaved, probate materials. Now, what are probate materials? Why are they valuable? Where are they located? What kinds of records are involved? Along the way, as I answer these questions, I'll give some examples of fragments that I've found. Probate records are important because they deal in part with inheritance of property. And as we know, the slave system considered people as chattel, personal or movable property, in other words. So property that involves neither land nor any rights or structures permanently affixed to it. Enslaved people could be transferred from one owner to another in several ways. Brian has been talking to you about one of those ways, i.e. through a bill of sale, deed of gift, or trust deed from one party to another while the owner is still alive. Those records might be recorded in deed books alongside land records, but then again, they might not be recorded at all. Probably a majority of them were not. Several other ways title to the enslaved might be passed on are reflected in probate records. At the end of an owner's life, all the debts and obligations that he owed would be tallied. All the assets that he had would be accounted for, including enslaved property. Debts due would be collected. If the value of the assets exceeded the debts and obligations at some point, the remainder would have to be divided in some way among the people entitled to inherit. Now, just exactly who would inherit? That was determined in one of two ways. If the person who died left a last will and testament, and in that case he would be called a testator, he could determine his own legatees within limits. That is why enslaved people are often mentioned in wills. Loose wills may be lumped into estate files, or they may be kept separate. They are always copied into will books when they are proved and become legal, so there are usually at least two copies. If the deceased person didn't leave instructions in a will, and we call a person like that intestate, what would happen? Well, the laws of the state would determine who qualified as next of kin. These laws were different in colonial or federal times from what they would be later, and in fact from what they are today. Each heir would receive a prorated share in the estate according to their degree of kinship to the previous owner. Now, a probate packet or estate file labeled with the deceased person's name includes all the loose papers associated with the settlement of an estate, including all the orders and the writs that the court issued to procure certain documents or actions, and all the returns, the claims, the complaints, and answers given into the court by the person responsible for the estate or by people who had business to settle with the deceased. Some of these documents might also be copied over into bound books that are called sometimes any number of things like records of estates or records of settlement, records of inventories and accounts, records of guardianship, etc. Now here's an important point for you to note. When loose estate papers don't exist or they are incomplete, look for the bound books of court records, which are usually indexed by the deceased person in the front or the back of the book. The person responsible for the property of the deceased until it could be distributed to the heirs was called an executor. Feminine of that is executrix, or an administrator. Feminine of that is administratrix. Executors were appointed by the deceased person in his will, always. So if you see the word executor, you know that there was a will, or executrix. The court always appointed an administrator to serve the same function. Now, that administrator could have a will attached to what he's doing, or he might not. More often, he has an intestate estate rather than a testator. Now, let's talk about some of the specific documents you will find in an estate packet. I can't talk about all of them, so I'm just going to focus on the ones that are of most value for researching the enslaved, but you need to be familiar with the full gamut so that you'll know what you're looking at and more quickly find what you want. I have provided a handout that describes each probate record type, so I encourage you to refer to that. One of the first places you'll see enslaved people mentioned during the probate process, or the process to settle any estate, is in the inventory or appraisement, which is a list of all the personal property, debts, and accounts due the estate. If it's an appraisement, it will also assign a value to each asset. Here they may be listed with their family group as well. An age may be given. Certainly small children will be listed with their mothers. Here I'm showing you an example from the estate of Reverend William Isaac Langdon. This is his inventory. Langdon founded High Point Female Normal School, which is one of my town's earliest educational institutions. And Langdon died within about a year in 1859 of when he founded the school. He owned 31 slaves who doubtless helped build and keep that school running, and here they are. Their names, ages, and note the interesting way in which they are grouped together. Everything about this list is significant. But there are other ways transfer of ownership can occur in probate records. Slaves were often sold to satisfy the debts of a dead owner. The person overseeing the estate could petition the court to do this. Personal property was always the first thing attached to be sold for debt, before land would even be considered. Now, this would happen when ready money or the proceeds of other property sold were insufficient to cover the debts. It's possible even that the slave owner mortgaged the enslaved person before he died, and the debt having gone unpaid till after his death, the creditors would come forward insisting on a sale. So this is one way that enslaved people were taken away from their homes and families and passed to other hands, sometimes even into the hands of slave traders. And this could be done with or without the consent of the original owners under court order. They were often sold at public venue or at public auction. Those 31 slaves I was telling you about in Langdon's inventory, well, many of them were sold to cover his debts at the petition of his administrator, who was his brother-in-law. and partner in the school, Samuel Lander. Lander was a teacher who wrote a math textbook for the state of North Carolina during the Civil War. Here's a list that he submitted of the enslaved he sold at the High Point Public Square on the 4th of April, 1860. Their new owners are given and the prices they paid. Now, just to think that these slaves were sold to pay for the costs of debt incurred in building and operating the school when they probably constructed it with their own hands. And in fact, this sale occurred on the public square, which was in full sight of the school. It's just stunning and amazing to consider what happened here. Now, after all the debts were paid, enslaved people could also be physically divided among the heirs, or they could be sold and the money arising from the sale might be divided instead. The fewer the number of slaves, or the greater the number of heirs, the more likely a division of proceeds would occur instead of an actual division of people among the heirs. Of course, some of the heirs could possibly be purchasers themselves in the lead up or sale working toward a division of proceeds. These documents will also frequently be found among probate records. Here you see how the enslaved in Langdon's estate were actually divided among the heirs of the deceased in a report that the administrator submitted to the court. In this case, in addition to the 31 enslaved people who were sold to satisfy debt, Langdon had a plantation near Beaufort, North Carolina, and the slaves from that plantation were summoned to High Point, where they were divided among the widow and children, who were all minors at the time, in equal parts by value, roughly, but not by the number of enslaved people. Now, these enslaved people were more fortunate because they would remain together until emancipation a few years later. The heirs were still minor, and there would be no need to have them physically divided from one another. There are some other reasons for sales of the enslaved within the probate process. On occasion, an administrator or executor might feel that an enslaved person had become a liability to the estate or would lose value if not sold. And this is what happened here. It's a case where an enslaved man named Madison, who belonged to a minor son of Thomas Scott in Guilford County, North Carolina, was being hired out year to year. The proceeds of his labor was being used to pay the upkeep costs of the child in this case. But the guardian felt that he was valuable, but he'd run away 3 times and was getting a reputation for doing that. So he would soon be worthless to even hire out in the neighborhood, according to this guardian. This petition tells where he was running away to and that his intention was to get to a free state. Subsequently, he would be sold to Isaac Weatherly, a local slave trader, under court order when they granted this petition. And sadly, he probably ended up being sold into the Deep South. If a set of heirs who inherited slaves were underage or incompetent, a guardian would have to be appointed for them to manage the enslaved people and whatever other property they had inherited, from minors until age 21 for boys or age 18 or the day of marriage for girls. The guardian was usually someone other than the administrator of the estate, but related to the children or trusted by the family. The guardian had to make a bond to carry out his duties faithfully, and he had to renew that bond regularly. If he failed in his duties, he might become the subject of a lawsuit. For our purposes, it's the annual accounts submitted by the administrators or guardians that can be gold mines for research of the enslaved. Each year, many of the more valuable enslaved people would be hired out to work for others in the community, and the money used to defray the ward's expenses, like in the previous example. So typical accounts include on one side all the revenue received, including from hiring the slaves out, and on the other, all the expenses. If the guardian is very meticulous in keeping his records, he might tell you who each slave was hired to each year on the revenue side and for how much. And on the cost side, he may give you a number of expenses related to enslaved people. So If a slave died and a burial had to be arranged, a coffin or winding sheet purchased, that might be noted. It's rare to find a date of death for an enslaved person. Here is one place that might happen. You might see a doctor or a midwife being brought in for a slave. That might indicate a child was born and about when. Or it might suggest a bout of illness and even what the illness might have been. You might see clothing purchased for the enslaved or other provisions. In one case, I found that a guardian had purchased a leather apron for an enslaved man, which suggested to me that he might have been a blacksmith or a tanner. The person to whom an individual slave was hired might also indicate a skill if that individual was a craftsman or mechanic, which you can find from other sources. If an enslaved person ran away, an expense account might show transportation costs or advertising costs to get him back. These are great little details that you could possibly find. In this case, you see an enslaved woman named Charity for whom a midwife was obtained in 1813. So please pay attention to the fine details. Finally, courts might hear legal questions related to slaves that belong to an estate. Related documents like complaints, answers, and affidavits or depositions can be incorporated into estate materials. For example, ownership rights over the progeny of an enslaved person bequeathed in a particular way. There might be a dispute over ownership, let's say, of an enslaved woman, left by her master to his wife for her lifetime or widowhood, but at her mistress's death, the will could direct that she or any of her issue were to be divided among certain other people. What if that mistress died 30 years after her husband? How many children and grandchildren of the enslaved woman might be involved? Where might they have been taken by that time? In the hands of how many different people in the family might they be held? Complex genealogies can sometimes be built from court cases related to estates, as in the chart that you see on the screen. All the details about slave relationships on this chart and the individuals concerned were taken from Nicholas Holt's estate file in Orange County, North Carolina. Some of the things documented here occurred decades after Nicholas's death. You may also find other kinds of disputes. Testimony might be given over mismanagement of slave property by guardians, administrators, or widows, including abuse or death. For example, I found a probate file in the Mason family in Marlborough County, South Carolina, and it documents how Louisa Mason, a widow, mistreated her slaves over many years, and there's a lot of detail and a lot of written testimony. Her children by her first husband were suing her for mismanagement because they were due to inherit these enslaved people, and they considered that she was diminishing their value by abusing them. Other disputes might question whether a widow had the right to even bequeath certain enslaved people. Were they her property? Did they come through her husband? Details about slave ancestry and how they came into the family could be detailed in such a case. Finally, enslaved people could have been designated for emancipation by their owner. Heirs frequently dispute these provisions in a will due to some kind of prejudice or incompetence that they allege. But the enslaved often found defenders, maybe an executor or a widow, who wanted to fulfill the deceased's wishes and free them, and may explain why they were being freed. The court cases may be documented in the estate file itself, or they may be separate among civil action papers or dismissed court papers, which is a completely different record series. It always pays to look at the court dockets in subsequent terms after an owner's death for any litigation that might not be included in the estate file itself. And I also want to encourage you to even look at the estate files of former white owners in the period of Reconstruction after slavery ended. If you're not sure who your ancestor was enslaved to in the prior period, maybe they were listed in the estate of a former owner as owing money or purchasing something at the estate sale. That could be a great clue as to who the enslaver was. So you see why probate records are so valuable. The enslaved are very often listed by name, and some attributes and details will be given about them. In the antebellum South, slaves were often the most valuable portion of any estate. Clearly, officials in the white family wanted to account for them. This might be one of the few times that they are mentioned by name in public records. The death of every owner usually results in a kind of census being taken of the enslaved in that household or on that plantation. But it's also a dangerous time. It's a time when enslaved families are subject to being divided and sold away. The documents may show how they were divided and where they went. And then, too, certain life events, interrelationships, and attributes of particular slaves could be revealed in the documents. Now, where will you find these treasures? In courthouses or state archives, that's where you're going to find the originals of these records, if they still exist. But digital versions are now widely available on the web for most states. So that's on Ancestry.com or FamilySearch.org primarily. If you're using Family Search, use the catalog function there to look for county records by searching the catalog for place and phrasing that place just like you see it on the screen. United States, comma, the name of the state, comma, the name of the county. So if I were looking for my county, it would be United States, comma, North Carolina, comma, Guilford. Then you look under the probate category for digitized records that you can view at home with a free account. On Ancestry, which is of course paid, you have to search the title field of the card catalog for a database for each state, and the title of each major probate database is phrased the same way. It's whatever the state name is, then wills and probate records. Now, you have to remember that if the records are indexed at all, and many aren't on either website, it's only by the deceased person's name, not by the slave's name or any other name. You have to suspect who may have owned your ancestor and search for that individual's will or probate packet looking for the names of slaves that you recognize. A lot of times it will be just like browsing through microfilm covering the years when a possible owner died and search several years afterwards as well, when their estate may have come to public notice. When you find an owner that you believe is the slave owner, try to determine which of their neighbors also owned slaves and look at their probate packets over the years too. Enslaved people frequently form relationships within their neighborhoods off their plantations. I recommend recording every bit of information that you find about every enslaved person in the neighborhood, because at the beginning, you won't know which enslaved people are your relatives and which are not. Follow the owner's family and try to determine backward in time how and from whom slaves may have descended within that family, and then trace the probate of those ancestors as well. But what about when enslaved people change hands between unrelated community members? One way to track them is through the bills of sale that Brian has been talking about. But if probate is involved, the only way is by completely surveying the surviving records and transcribing and indexing within a neighborhood every enslaved person's name and every enslaver's name. As I said before, sometimes you just don't know where to look. Enslaved people can be among the most mobile people in the Old South. I'm surveying and publishing estates for Guilford County, North Carolina right now. I've gotten through several letters of the alphabet and 2 books are ready to publish. I'm planning to do the same thing for Marlborough County, South Carolina, where many black transplants to our city of High Point originated in the early 20th century. In fact, I'm including virtually every name mentioned in each file, and you can see an example of my work on the screen for the Joseph Smith estate of Guilford County. When you get familiar enough with these records, maybe you will consider doing the same for your counties of interest. We certainly need more comprehensive indexing projects which sweep in these tiny fragments and reclaim the mosaic of our forgotten past. With our combined efforts, they need not remain forgotten. I want to thank you for your attention today. My name is Larry Cates again, and I've been a genealogy librarian in High Point, North Carolina for 13 years. I began researching my family over 30 years ago, and since then, I've edited numerous historical and genealogical magazines, including the North Carolina Genealogical Society Journal. For the past several years, I've been publishing a number of books of local records. If you have any questions about this presentation, since I'm not available to answer them on site today, please don't hesitate to write to me at larry.cates@highpointnc.gov or leave a message at my work phone directed to me at 336-883-3637. I'd love to hear about your work.